Hello, and welcome to JD Advising's California Bar Exam Essay Guide. The goal of this guide is to help you find an effective and efficient approach to the California Bar Exam essays right from the very beginning. This guide will help you feel confident on test day so that you can conquer the essay portion of the California Bar Exam. If you have any questions about this or other resources we offer for the California Bar Exam, please don't hesitate to contact us. Some of our other resources include a California Bar Exam prep course, private tutoring, essay feedback, and one-sheets. If you reach out to us, we'd be happy to speak with you about the resources that can best help you prepare for the California Bar Exam. We hope you enjoy this guide and good luck on the exam. The next subject is evidence. This subject is tested both on the multiple choice and essay portions of the California Bar Exam. In fact, this is the only MBE subject where California heavily tests California distinctions when this subject is tested on the essays. So there is a lot of law to learn for this subject. First, let's talk about how evidence is tested on the essays. Evidence is tested about once each year, so approximately every other administration, and California either tests the federal rules of evidence or the California Evidence Code. Federal law and California law are each tested about 50% of the time, but don't assume that they switch every administration. So for example, just because they tested California law the last time they tested evidence does not necessarily mean that they will test federal law this time, or vice versa. So you should learn both the federal rules and the California Evidence Code to be fully prepared for this subject. Evidence is usually tested on its own, but could easily be crossed over with just about any of the other subjects. In recent administrations, we have seen evidence crossed over with civil procedure, professional responsibility, and remedies. Next, let's talk about the highly tested issues on evidence essays and also some of the distinctions that are tested frequently. Before we get into the law, I want to talk about how California likes to test this subject and how you should structure your answer to get the most points. You will usually be given a fact pattern where the parties are attempting to admit anywhere from 3 to 5 pieces of evidence, and your job is to discuss whether each piece of evidence is admissible. For each piece of evidence, you should contemplate all of the evidentiary rules that might affect the admissibility of that piece of evidence. So for example, in analyzing a single piece of evidence, you might need to discuss relevance, hearsay, authentication, and the witness testimony rules. And then you have a second piece of evidence, and for that one, maybe you need to discuss relevance, hearsay, and impeachment. Because of this necessary approach to evidence questions, it is a good idea to have a checklist in your head of all of the evidentiary rules and have it memorized so that you can run down your checklist for each piece of evidence to make sure that you're discussing every potentially applicable rule in your essay answer. Now let's talk about some of those highly tested rules. The first rule I want to mention is relevance. You almost certainly need to discuss the relevance of each piece of evidence in the fact pattern. Actually, you need to discuss two types of relevance: logical relevance and legal relevance. Evidence must be both logically relevant and legally relevant in order to be admissible. Evidence is logically relevant if it's offered to prove or disprove a fact that is of consequence in determining the action. The California Evidence Code also requires that the fact be in dispute. However, this is not a requirement of the federal rules of evidence. Legal relevance means that the probative value of the evidence is not substantially outweighed by a risk of unfair prejudice, confusion of issues, or misleading the jury. This comes from California Evidence Code Section 352, and the federal equivalent is Federal Rule of Evidence 403. Be sure to state each rule separately, analyze whether each piece of evidence is logically and legally relevant, and then come to a conclusion on each one. Basically, you should have 2 mini IRACs, one for logical relevance and one for legal relevance. The other highly tested issue I want to discuss is hearsay. This issue comes up on pretty much every single evidence essay, so you should be well prepared to discuss this topic. Furthermore, there are some distinctions between the federal hearsay rules and the hearsay rules in the California Evidence Code that you must be aware of in the event that California law is tested on your essay. Start with the definition of hearsay. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. So if the statement is not being offered for its truth, so for instance, if it's being offered to show that it was made, then it's not hearsay. One commonly tested hearsay exclusion is effect on the listener. For example, if I tell my neighbor that he has a flat tire and then he gets into his car and gets in an accident, the victim of the accident might want to offer my statement not to show that the tire was actually flat, that would be the truth of the matter asserted, but to show that the neighbor knew the tire was flat. In other words, it is showing the effect, here would be notice, on the person who heard the statement, my neighbor. So this is not hearsay. One of the exceptions to hearsay that we see tested from time to time is for statements against interest. And there's a minor California distinction to be aware of here. Under the federal rule, a statement against interest is admissible as an exception to hearsay if the declarant is unavailable, the statement was against the declarant's pecuniary, proprietary, or penal interest, it was against the declarant's interest when it was made, and the declarant knew it was against his interest when the statement was made. So for example, a man is sued by his employer for stealing money from the employer. The man's coworker told a friend, I helped steal the money. The coworker cannot be found, so he is unavailable to testify, but the friend will testify as to what the coworker told him. This would be considered a statement against interest. The declarant is the coworker who's unavailable. He made a statement against his penal interest by admitting to committing a crime. It was against his interest at the time he made it because he had already committed the crime, and he knew it was against his interest because he knew that what he did was a crime. In California, a statement is admissible as a statement against interest if it is against the declarant's social interest as well. So for example, if a man admits to cheating on his spouse, that could be considered against his social interest and could be admissible in California. Another highly tested exception is the present sense impression exception. The California Evidence Code does not recognize this exception, but does have a somewhat similar exception for contemporaneous statements. It is crucial that you know the difference between the two rules. So under the present sense impression exception, a statement is admissible if the declarant is describing or explaining an event while it occurs or immediately thereafter. Under the California Evidence Code rule for contemporaneous statements, the statement is only admissible if the declarant is describing his own conduct and the statement is made while the declarant is engaged in that conduct. So for example, if I'm a passenger in my friend's car and my friend gets into an accident, and right after the accident I say, you were driving way too fast, that may be admissible under the federal rules because I am describing my friend's driving right after the conduct occurred. However, it would not be admissible in California because I am describing my friend's conduct, not my own, and I don't make the statement until after she is done driving, so it's not being made while the conduct is occurring. California's rule for contemporaneous statements is much narrower than the federal rule for present sense impressions. As I mentioned previously, some of the other rules that often come up on evidence essays include authentication and the best evidence rule, which is called the secondary evidence rule in California, but the rule itself is essentially the same. Impeachment, and specifically prior inconsistent statements, which is the most tested method of impeachment, and also witness testimony. Whenever the question is about witness testimony, you should identify the person as a lay witness or as an expert witness. A lay witness must have personal knowledge of the subject about which they are testifying. Their testimony must be rationally based on their perception, helpful to the trier of fact, and not based on scientific, technical, or other specialized knowledge. An expert witness does not need personal knowledge, but can testify based on facts they learn at or for trial, so long as their testimony is helpful to the trier of fact and based on sufficient facts or data. Be sure to fully discuss whether the lay witness has personal knowledge or whether the expert witness is testifying based on sufficient facts or data when applicable. As I mentioned before, it is strongly recommended that you approach evidence essays with a checklist of potential issues. Some people find it helpful to have multiple checklists. For example, you might have one checklist for potential issues for documentary evidence, and then another checklist for issues for testimonial evidence. There have been evidence essays with as many as 30 issues to discuss, so having these checklists will ensure that you are able to very quickly identify all of the issues and get to writing right away. There is often a lot to write about in evidence essays, so you need a very efficient approach to be able to get everything into your answer within an hour. Finally, it is so important that you practice California evidence essays for a few reasons. First, as I just mentioned, there's often a lot to write for these essays, so it can be tough to fit everything in 1 hour, and so you must work on timing. Second, some California distinctions are tested much more frequently than others. Completing past essays will help you see which California distinctions are the most important and most highly tested. And third, you will see that there's a pattern and certain approach to answering evidence essays. For example, I mentioned that you should always discuss relevance at the beginning of an essay. When you're looking at the sample student answers, you'll notice that logical relevance and legal relevance are the first two issues for every single piece of evidence in the fact pattern. Completing practice essays will help you see these types of patterns, and this will allow you to quickly and efficiently answer evidence essay questions. We recommend that you start your practice by reviewing the evidence essays from February 2021, February 2020, February 2019, and February 2017.